Today we're joined by two members of the CRIPS construction team, James Lee and Iain Benson. James is a partner in the construction team, advising on all aspects of non-contentious construction matters. He covers a full range of construction engineering projects for quite a wide spectrum of clients, including property developers, institutions, public authorities, contractors, consultants and funders as well. Iain is a legal director, again in our non-contentious construction team. He's got over 20 years of experience, both as a solicitor in private practice and in-house for one of the UK's top 10 main contractors. He's worked on some landmark building projects as well as some infrastructure projects as well. So we're, just by way of introduction really, we're 2 years in, over 2 years in now, since the Building Safety Act received royal assent in 2022. I think dust is finally starting to settle on all things building safety related. And it's not really surprising that there was a lot of excitement across the industry in the spring when JCT announced the release of its 2024 suites of building contracts. We had the design and build contract being released in April, and shortly thereafter, you might recall, the minor works contract was released. And the hope was that these new suites of documentation would tackle building safety issues as implemented by the Building Safety Act. The title of today's session is The New JCT, as easy as ABC, or is it? And what we intend to do over the next 45 minutes or so is to discuss the changes that have been made to these suites of documents. And most importantly, sort of talk around the effect that these changes might have in practice. And how we're going to do that is in two parts. Firstly, James and I are going to discuss the key developments in JCT contracts more generally. And then Iain and I are going to talk about the new duty holder and competency regime, obviously introduced under the Building Safety Act, and take a closer look at those changes that it will bring for clients, contractors and designers, and obviously what the likely impact of those changes will be, with the intention of bringing things full circle at the end and discussing how that duty holder regime has been implemented in the new suites of JCT contracts in terms of the drafting. So turning first to James, come on to the first topic of our webinar, which is the new JCT changes. Obviously, we've now got our new JCT D&B and we've got our minor works contract issued. What's your sort of overall impression of the changes so far?
Well, the changes have been described very much as an evolution to the JCT contract rather than a revolution. That's very much the best way to describe them. The vast majority of the JCT has been left untouched. So whilst there's some significant changes that we're going to explore today, I think it's fair to say we've been a bit surprised by how limited the changes have been. There's been a lot of talk and speculation over the last few years about what JCT might do with their next version. We've had a lot of issues in construction over the last few years. We've had COVID, Brexit, high inflation, supply chain issues, climate change, ESG, and of course, building safety. And that could have prompted the JCT into a lot of drafting changes, but that hasn't really happened. I also think it's fair to say the changes to the contract are, on balance, probably contractor friendly. But let's go through them, and people can make up their own minds.
Yeah, let's look at the changes in a little bit more detail. Now, we do have some slides to put up on the screen so that you can follow the changes in the wording, the wording of the changes. And the text in red on those slides show the updates, so the new wording introduced by the JCT 2024. I'd like to say let's start at the very beginning, but actually let's start with the hot topic of the moment, and that is the Building Safety Act. So you did touch upon it a little bit earlier in terms of the changes being limited. So this section is sadly not as long as we probably had hoped it would have been, but what has JCT done in relation to building safety?
Yes, well, actually, as you've kind of implied, not a great deal, to tell the truth. So there seem to be two levels of drafting that you need to consider in a building contract when thinking about the Building Safety Act and the recent changes to building regulations generally. Starting with the basic level, there are certain obligations that will apply to every works project, irrespective of what that is. These mainly centre around the new duty holder obligations under Part 2A of the building regulations, which Iain is going to talk about in more detail later. But suffice to say, from a contract drafting perspective, it works much in the same way as the CDM regulations work. So we're all now used to wording going into contracts that needs to identify who your principal designer and your principal contractor are for CDM purposes. And then there's a general obligation on the parties to comply with the statutory obligations under those. Well, the new Building Safety Act wording works pretty much in exactly the same way. In fact, they even use the same terms, principal designer and principal contractor, which is not in any way confusing for anybody, of course. As the two processes are so similar, JCT have basically just combined the two by adding references to new building regulations into the existing CDM wording, which viewers will hopefully be able to see up on screen. So firstly, Articles 5 and 6 have been amended to allow for the new nominations for the new building regulations roles. And then Clause 3.16 has been amended to confirm the party's general compliance with the building regulations. Now, in its guidance note, the JCT has also pointed out that the Building Safety Act will fall within the definition of statutory requirements under the contract as well. So there is a general requirement to comply with the Act through that provision as well.
So that's the basic drafting, but everyone hopefully with us today will be aware of the fact that we've sort of got two regimes running, and we've got this enhanced regime in respect of higher risk buildings under the Building Safety Act. Is there anything to note in particular as to what changes JCT have made in relation to higher risk buildings?
Yeah, so basically nothing's been done in respect of high risk buildings, unfortunately, which is perhaps the most disappointing thing about the new contract. We understand the JCT's reasoning for doing it. Their reason is that they consider that projects for high risk buildings are just one type of project that their contracts might be used for, and there isn't special drafting for other types of projects either, which is true. However, the new Building Safety Act regime is complicated, particularly around information requirements, the competency framework, and the various gateway approvals that are needed for the various stages in the project. And I think we're all eagerly anticipating what JCT might propose by way of procedure to deal with it all. JCT has always been a thought leader in construction procedure, and where it leads the industry tends to follow. So as it stands, it's basically going to be left to the market to work out how to deal with all the amendments that we're going to have to see in JCT contracts to deal with high risk buildings. So anyway, so the way we're actually organising this webinar, I'm dealing with the changes that have actually happened with the contract in this first half, and then Iain's going to be looking at the Building Safety Act more generally in the second half, and is going to offer some thoughts then as to things people need to start thinking about if they're drafting a JCT contract for high risk buildings.
Yeah, I mean, I think it's disappointing personally because it's extremely complex, and therefore the drafting that's going to be required is going to be, it would be nice to have an industry standard benchmark or precedent to work from. So there'll be a lot of drafting that has to develop. I mean, I think the second reason why it's a bit disappointing is it seems that the new JCT 2024 was initially prompted by the new Building Safety Act, so you would have thought that they'd take that opportunity to incorporate those elements into the new suite. Anyway, setting that aside for a moment before we will discuss, as you said, we'll discuss further with Iain a bit later on in today's session. Let's move on for now to talk a little bit about the other changes to JCT. And I think a good place to start is probably the design duty of care.
Yes, so yeah, this is an important change. So for a long time, the wording of the design duty of care in JCTs has talked about the contractor having the same liability to the employer as would an architect or other appropriate professional designer who holds himself out as competent to take on that work. Now, the general view amongst construction practitioners is that that wording is pretty unclear as to what it means. And therefore, it has been routinely amended through schedules of amendments to change that to a more reasonable skill and care type standard instead, which of course we see in 99% of consultant appointments, and that's also the duty of care that PI insurers will generally cover too. So the JCT 2024s have now adopted this approach, stating that the contractor will use the reasonable skill and care in such design to be expected of a qualified and experienced architect or other appropriate designer undertaking the design of works, scope and character to such design of the works. So that wording should be up on screen now, hopefully. So in practice, whilst this is a large change for JCT, actually it just follows generally what's been happening in the market anyway. Then there's a second change to discuss, which is new clause 2.17.1.2, and that states that under no circumstances will the contractor be subject to any duty, obligation or liability which requires that their design will be fit for purpose. Now, that's something that contractors have been worried about for a long time. There's been case law that has held that despite only having a general reasonable skill and care obligation under a contract, any kind of guarantee of performance that might be written in a technical document or a performance specification attached to the contract, that could still bring in a fitness for purpose obligation, which may not be covered by insurance, of course. So whilst the new blanket wording on excluding all fitness for purpose obligations seems sensible, it is still worth some thought about whether that should actually automatically apply to everything under your contract. So, for example, compliance with statutory requirements is often seen as a strict requirement and absolute obligation, and things like designing a building to the exact dimensions an employer wants with all that liquidated damages attached, that's often seen as a strict requirement too, as employers want to know that will be the size of their building. So it might be that market practice actually develops to carve out things like that, which are absolutely crucial to the success of a project.
It'd be interesting to see how things develop actually on that front. I think that quite comprehensively wraps up design liability. Let's move on. There's a fair amount to discuss in relation to delay. Quite a few changes actually around delay in the new suites. Let's start firstly by talking a little bit about the new delay events.
Yes, so let's start with two new delay events, known as relevant events, of course. So these potentially give the contractor an extension of time to the target completion date if they occur. And there are two main changes to the relevant events list, both of which seem to be prompted by COVID. The first is directly related to COVID, and that's a new epidemic event. This is an epidemic which limits the availability or use of labour, or which prevents a contractor from securing goods or materials that are necessary for the proper carrying out of the works. Now, firstly, it doesn't actually define epidemic, so it's a small e. So we're not exactly clear what that means. We can probably only go on its normal dictionary meaning for now, and I looked that up. So it's something along the lines of a widespread occurrence of an infectious disease in a community at a particular time. So that's potentially really far-ranging until perhaps we get some court guidance on it. More probably, lawyers like us will be itching to give it a definition ourselves. It also doesn't prescribe where the epidemic may take place, or that it needs a direct effect on the works. So there are potentially quite a few holes that might need to be plugged if that new event is going to be used. I can see this new event prompting some debate. A lot of the employers we work for have been refusing COVID type wording recently in building contracts on basis that it's now gone, hopefully. Arguably, if we had another epidemic generally that had the same effect as COVID, we'd be back into treating that as a force majeure event, as we did mostly with COVID. However, on the other hand, COVID did have such a massive impact. You can see why contractors are worried about that happening again. So I think it will be up for debate as to whether people keep or delete this new event from contracts. Then we've got the second relevant event, which is an expansion on the previous change in law wording that occurs after the base date, which now includes any new statute, statutory instrument, or other subordinate legislation, regulation, or bylaw, or the exercise of a statutory power, or the publication of any guidance by the UK government or any local or public authority. So in the case of guidance, this also expressly includes guidance from the Construction Leadership Council. Now, the new reference to guidance is interesting, as that seems to be a response to lessons learned from COVID as well. So if everyone recalls, there's a lot of confusion at the time as to what rules the construction industry should be following. There's no official shutdown of sites or any official government legislation. And the industry was largely left to working out itself all the safety rules that applied, and more importantly, who bears the time and money risk and all of it. So thank you, Boris. That's good. And that looks to have inspired this new reference to guidance. Some people are questioning whether that reference is quite right, is only applying to guidance from the Construction Leadership Council. That might not extend to, or wouldn't extend to, for example, building safety guidance, which is generally issued by the Health and Safety Executive, or even the new Building Safety Regulator. Others are saying that's possibly too wide and you shouldn't extend to guidance at all, potentially with, you know, really important time and money implications in play. So I think that one's going to be up for debate again, really, as well. Also, some commentators have pointed out there's actually no general obligation on the contractor to comply with guidance in the definition of statutory requirements. So there seems to be an inconsistency there, which may see more amendments being brought in to deal with that.
You mentioned time and money a lot. So obviously from a commercial perspective, I think everyone will probably want to know, are we looking at these relevant events becoming relevant matters? Do these relevant events, as they are at the moment, lead to loss and or expense claims as well?
So not by default, actually. So there's a new option whereby you can elect to have these count as relevant matters as well. But by default in the JCT, these are only relevant events. JCT are effectively treating them as cost neutral events between the parties. So the contractor is not entitled to claim extra money, but will also not be on the hook for liquidated damages either. But you can change it, and you can opt these in as relevant matters as well. And then one further point to mention on these new events is that they've also been added to the termination provisions as well, under clause 8.11, so that if the works are suspended for either of these two reasons for a continuous period that's specified in the JCT contract particulars, and that defaults to 2 months unless you change it, then either party can serve notice on the other and terminate after 7 days thereafter if the event continues. So that's something to watch out for as well.
Yeah, definitely. So we've got our two new relevant matters, which can be magically converted into relevant events, which can be converted into relevant matters by option. Just sticking with delay for a moment, there have been a couple of tweaks in the way that delay is actually assessed under the contracts, and I think it's worth just touching upon that.
Yes, so there's a couple of new time periods to be aware of. So firstly, if the employer has received notification of a relevant event and it decides it needs further details about the claim in order to assess it, then it would need to ask for this further information within 14 days from the notification. So that's a new time period to be aware of. Then secondly, there's a reduction in the amount of time the employer has in order to confirm its decision on an extension of time claim. So previously under clause 2.25, the employer needed to notify the contractor its decision within 12 weeks following the notification. Now that's been reduced to 8 weeks. So employers and quantity surveyors will need to decide whether that's enough time.
And while we're in delay territory, and just to sort of tie up on delay, it would be a bit remiss not to talk about liquidated damages. So, and there has also been a tweak to those provisions as well, hasn't there?
There has, yes. So there's a new clause 2.29.5, which clarifies the position regarding the employer's ability to levy liquidated damages if the contract is terminated. And this follows a Supreme Court decision called Triple Point Technology. So the JCT now states that where a date of termination occurs before practical completion, then liquidated damages only apply between the target date, practical completion, and the date of termination. So basically, the employer can't levy liquidated damages after the contract has been terminated. So that might influence some decision making if something's going wrong with your project, and an employer's considering all the options available to it. It could have quite important consequences for the ability to recover liquidated damages.
So that wraps up delay. We're going to look now at it's an interesting new article actually that's appeared at the front of the contract, and it relates to this concept of collaborative working, which is actually a theme that sort of runs through the Building Safety Act more generally, and has been something that's been talked about a lot over the last year or so, in relation to parties to a project having an obligation to collaborate and cooperate. And we see it not only in the context of new build, so the construction of new buildings, but also in the management of existing buildings, particularly in relation to the roles of the principal accountable person and your accountable person, and also the responsible person. So the extent to which people are obliged on a project or in relation to a building to cooperate, share information, collaborate. Just in the context of JCT in particular, do you think this this new article, or the introduction of this new article, introduces or marks a shift in approach for JCT from or to more of an NEC style approach?
Probably not that far, but it's a step in that direction. So the new article in question is up on screen, and states that the parties will work with each other and with other project team members in a cooperative and collaborative manner, in good faith and in the spirit of trust and respect. And to that end, each will support collaborative behaviour and address behaviour which is not collaborative. So the first thing to say is that this is not new wording for the JCT. It was actually an optional clause before, found in supplemental provisions, but it's now been moved front and centre into the contract. So it applies to all contracts now. In theory, whether or not market practice develops to delete it, who knows, but it's perhaps a difficult argument to make to delete it. It would definitely not set a good tone for the project moving forward. It also brings the standard contracts more in line with the government's construction playbook as well. So it's hoped that by moving the statement front and centre within the contract, it will have more of an impact in establishing good working relationship between the parties from the start. As with most good faith type clauses in contracts, it doesn't mean a great deal legally. It can often be used to strengthen legal arguments where there's kind of clear dishonesty on the part of one of the parties, but would not usually in itself give an action for proceedings. You'd normally need kind of a good basis for starting a claim from other areas of the contract. So, for example, to terminate, you're still looking at the specific grounds to make that happen, and you can't do that vexatiously anyway. If you're for extension of time or loss and expense claim, it still involves the proper assessment of a relevant event or a relevant matter. You might look to add in any examples of dishonesty or not acting in a collaborative way into your arguments, but that by itself is unlikely to be strong enough. However, that said, we don't have any particular case law on this particular wording to my knowledge, so it might develop in a different way.
Yeah, certainly one to watch. Now, if there's one thing that people are talking about when they're not talking about building safety, it's ESG, environmental matters and sustainability. It's at the top of everyone's agenda, really, in construction, in the property industry more widely, and speculation was rife that JCT were going to incorporate ESG related or type provisions into its contracts. What has actually happened on that front?
So unfortunately not a lot on that front. So we've always had an optional supplemental provision whereby the contractor is encouraged to suggest economically viable amendments to the works, which, if instructed as a change, may result in an improvement in environmental performance. Plus, there was a provision that the contractor will supply all information regarding the environmental impact of the supply and use of the goods and materials involved that the employer reasonably requests. So basically, that same wording albeit it is slightly wider as it now refers to sustainability and reduced environmental impact as well. That same wording has been moved from the supplemental provisions into the main conditions of the contract, and its new clauses 2.1.5 and 2.2. So again, there's a shift on emphasis on making it all more mainstream. There's not anything further than that in the contract, in the new contract. So things like referencing certain environmental standards for your works, looking at supply chain issues, calculating a project's carbon footprint, or setting other ESG KPIs, etc. They'll all still need to be brought in by bespoke amendments. As a further tip, if viewers are interested, they can Google the Chancery Lane project for potential drafting around ESG issues. Plus, JCT have promised some further thoughts when they update their standard pre-construction services agreement as well. So we might get more then.
Yeah, I mean, it seems we've got a bit of a sort of underlying theme developing with moving similar concept drafting from supplementals into the front end, but actually the effect is somewhat limited. And it seems a shame with the SG, because it seemed like a good opportunity to, you know, move forward on that front in terms of the industry standard documents.
Yeah.
Anyway, let's talk. There have been some changes to clause 315, so let's just talk about those briefly.
Yes, so clause 315 previously entitled the contractor to a relevant event and a relevant matter if it discovers fossils, antiquities, or other objects of interest on the site. So that's now being expanded to also include the discovery of asbestos, contaminated material, and unexploded ordnance. Now that's really important, or it is really important to realise that it's qualified for asbestos and contaminated material. So a relevant event or a relevant matter is only granted where it has not been identified in the contract documents. So, for example, both the presence of asbestos or contamination can be the subject of pre-contract reports and or surveys, which then get included in the contract documents. And so anything found within those is already deemed to be factored into the contractor's pricing and programming. But anything else that's found further to that will then be at the employer's risk under this new wording. So that's interesting because these elements often form quite detailed pre-contract discussions on contractual liability for finding adverse site conditions, particularly ground conditions. Employers, for example, will often ask the contractor to take the full risk on these items, provided the contractor has had opportunity to undertake full surveys during the pre-construction period. We've also been involved in lots of compromise discussions over the years about what's dark ground, what's not dark ground, etc., etc. So if that sort of discussion is going on, you need to think carefully about how this new wording interacts with that, as it could potentially cut across all of that.
Now, as lawyers, we love a general sweeper clause. So let's do a general sweep up of the remaining provisions of the JCT. I think there were just a few last points to mention before we go on to discuss the duty holder regime in a little bit more detail.
Yes, so I'll just mention a few more key changes to be aware of, which are listed on the slide. So firstly, there's been some general updating of legislation referencing. So for example, the definition of insolvent has been updated to reflect changes introduced by the Corporate Insolvency and Governance Act 2020. And references to the Public Contracts Regulations 2015 have changed following changes in the applicable law following Brexit. So that's the first one. Then the second one, the JCT has also modernised the language used in the contract. So it is all now gender neutral. I mean, it did always look a bit funny referring to the contractor as a he. It's now an it. So that's part of the modernising process. Then thirdly, there's a new option set out in the JCT contract particulars to enable formal notices to be served by email. Now, that seems sensible as everything gets done by email these days, but it's important to note that things like payment applications, other payment notices, or even adjudication notices can now all be served that way, all of which have potentially quite severe consequences if missed. So it might be a good tip for people to have several email addresses noted down as a kind of fail-safe if you are going to choose that option. Then there's expanded provisions for working out how and when payments are due to the contractor in a termination situation. So by and large, it's basically still the same procedure around termination, but they didn't have all the usual Construction Act provisions relating to the termination payment. So due date for payment, final date of payment, payless notices, payment notices, etc., etc. So that's all now been added in. We've got a requirement for parties to try to resolve disputes through negotiation with each other first before any formal legal proceedings are commenced. And again, that's something else that's been moved from the supplemental provisions into the front of the contract. So that seems sensible. I imagine most disagreements on site are resolved by negotiation rather than anything else. So that seems sensible too. And then lastly, we've got the execution clauses have now been amended to recognise that the contracts can be signed via electronic signature now, which is again following how the market's gone in contract signing now. We're all using platforms like DocuSign, etc., to get them signed. So that's just another kind of modernising thing, really. And that is pretty much it. As I said at the beginning, there are definitely a few significant changes to be aware of and we'll need careful thinking about, but this is an evolution of the contract rather than any radical change. And the vast majority of JCT procedure that we all know and love has remained the same.
Yeah, thank you very much, James. One element of the building safety sort of landscape that has been picked up by JCT, I would say that they have grasped the net. Iain will probably go on and tell me that they haven't. Well, they may have grasped it, but he may say something else about it as well. Just in terms of industry movement, we've obviously got a new JCT suites, the 2024 suites. Also, I just saw that this morning, CLS have just released their letter of intent 2024, and that again picks up on this duty holder and competency regime. So we are getting sort of updated industry standard documentation coming through as well now. Now, Iain, the duty holder regime, obviously a completely new concept under the Building Safety Act. I think let's build the foundations, and probably the best way to start is to talk about what a duty holder actually is in the first place.
Yeah, I mean, just before I go into what a duty holder is, I think it's important to just mention at this stage, there will be handouts given out to those that are participating, the viewers on the seminar today, because there's a lot of legislation that I'm going to talk about here and referencing of acts, statutory instruments and regulations. So you don't need to sit there scribbling it all down on a note. We will be issuing a guidance brochure note that goes with all of this. But in terms of what a duty holder is, as you said, it all derives from the introduction of the Building Safety Act 2022, which is of itself was a consequence of the Grenfell Tower fire, and also the Dame Judith Hackett report into building safety following the fire, resulted in the Building Safety Act 2022. The Building Safety Act 2022, alongside it, brought in the catchily named Building Regulations, etc. Amendment Act, England Regs 2023. There are other regs in respect of Wales and Scotland as well. And that included in that regulation a change to the Building Regs 2010, which put in the Building Regs 2010 a new Part 2A. The new Part 2A was entitled Duty Holders and Competence, and that sets out what effectively a duty holder is and who they are. So the Building Regulations Amendment Act creates duty holders for a contractor is a duty holder, a client is a duty holder, a principal contractor is a duty holder, and the same in respect of designers and principal designers. Effectively, the role of the duty holder responsibility is to make sure that each of these entities responsible for the construction works on a project are also responsible. They have a duty to ensure compliance with the building regs and the higher safety standards brought in by the building regulation regime, the new building regulation regime.
Yeah. I think in terms of the Building Safety Act, there's two things really that catch people out. The first thing is working out what's in force when. And that obviously is dying down a little bit now as more and more of the Act has been brought into effect by virtue of secondary legislation. The second limb that catches people out is which bits of it apply to what works or what types of building. And I think in relation to the duty holder regime, this is a really pertinent point. So I think do you want to just briefly explain when the duty holder regime applies?
Yeah, I mean, that, as you say, it's the biggest mistake that everybody makes. They assume that the duty holder regime only applies to higher risk buildings. It doesn't just apply to high risk buildings, it applies to all construction works, and all construction works are defined in the Building Regulations 2010 and its statutory instrument 210-2214. As I say, that's all in the notes. So the duty holder regime applies to all works unless, and that's unless, they are exempted under Regulation 9 of the Building Regulations, or they constitute what are considered to be minor works, which are defined in Schedule 4 of the Building Regulations. And that ties into what James said earlier, is when JCT committee decided to update and amend the JCT forms, they put in there the appointment of duty holders and an obligation to comply with statutory requirements. They didn't deal with anything else in relation to higher risk buildings. So it applies to all works pretty much generally, unless exempt or minor works. And the government has issued guidance on that as to what those works are, if you're in any doubt.
As you say, we've got this enhanced regime that relates to higher risk buildings.
Yeah.
Just for the sake of clarity and just to conclude, also laying the foundations for this new regime, do you want to just briefly talk through what a higher risk building actually is?
Yeah, apologies for all of those out there that have heard this repeated so many times in the last 2 years. I'm sure you all know what a high risk building is, but if you want to go back and check, you'll find it under Section 120D of the Building Act 1984, which defines a high risk building as a building that is at least 18 metres in height or has at least 7 stories, and is also defined as a description specified by the Secretary of State as being a high risk building. Now that gives the option on the Secretary of State to add in additional classes of building, which would be a high risk building. But for the purposes that we're talking about at the moment, a high risk building is defined as a building that has got at least 2 residential units. All care homes are high risk buildings, and all hospitals are high risk buildings. There are exemptions from the high risk building regime, normally things like barracks built by the MOD or kind of state entities, but all of the exceptions are contained in the regulations, and as I say, that's in the notes.
The important point to note is that you could have a building that can become a higher risk building by virtue of development. So
Yeah.
you have a building that's under 18 metres and you build out on top and you take it to more than 18 metres, you're into high risk building territory. Equally, if you've got a building that's 6 stories and you put on an extra story or 2, you're then brought within the scope of the regime as well. So that's something definitely to bear in mind.
I do think that that's important, as you say, because when we're talking about duty holders, and we'll go on to the role of duty holders later on, but one of the key things that is in there is that the duty holder has to recognise if a building that they are working on that isn't a higher risk suddenly falls into that category due to changes that you talked about, variations to the works.
Now we're going to talk the general duty holder obligations sort of form a nexus, and it's quite complicated to work out who should be doing what, and the sort of interrelationship between the various different duty holders. We're going to go on to look at that in the context of each specific role in a moment. But I think, and before we do that, it'd be useful just to outline, sort of by way of summary, what general duty holder obligations are.
Yeah, so we've got classes of duty holder that I mentioned before: contractor, principal contractor, etc. What applies in terms of general duty holder obligations, they apply to all of the specific class of duty holder. So within that general duty holder obligation, you've got an obligation to to make sure that the works that you are carrying out are planned, managed and monitored to ensure that they comply with the building regs. You've got an obligation, a general duty across all duty holders to cooperate with each other to, once again, to achieve compliance with the building regs. And there's also an obligation to ensure that the works are compliant with the building regs. I know it's a bit repetitive, but it's all, you have an obligation to carry out certain behaviours, certain obligations to achieve those building regulation requirements. In relation to Regulation 11E, there is a requirement for any person who appoints another to a duty holder role to make sure that they've got the competence as well. So even if you're not talking about a higher risk building, you're talking about the general obligation and you're appointing a duty holder. If you're the client and you're appointing a contractor, you need to be able to make sure as your general duty holder obligation that they have the knowledge and understanding of the building regulations and that they have the ability to comply with those regulations.
Before we get on to the specific roles, let's just talk about the enhanced regime, so the additional duties for higher risk buildings.
Yeah, so we've covered off general duties. On top of that, if you've got a higher risk building under Regulation 11E, there's a need on the part of anybody appointing a duty holder to check that there is no serious sanction against them in the last 5 years. And what I mean by serious sanction is that anybody that's appointed to the duty holder role as contractor or designer hasn't had a compliance or stop notice issued against them under the building safety regulations, or a conviction, for example, under the Building Act 1984 or the Health and Safety at Work Act 1974. So you need to make sure that they haven't breached the obligations in the last 5 years, because that's indicative of compliance. In addition to that, for higher risk buildings, there's an obligation there on the duty holder to make sure when they're appointing somebody that they can demonstrate that they've carried out the appropriate due diligence to check that they comply with that requirement, that they've checked that there is no sanctions against the duty holder that they're appointed, so that the building safety regulator can come back and say, right, okay, you've demonstrated to me that you've carried out the due diligence, you've checked these guys, girls out and made sure that they're okay to do the job.
Yeah. And we're going to move on and talk a little bit about the competency element of the duty holder and competency regime in a moment. Mm-hmm. Let's talk specifically now about specific roles under these duty holder obligations. I think probably the best place to start is the client role.
Yeah, I mean, the client duty holder role is the overarching role to ensure that there's compliance with the building rig, the new building regs. So ultimately, the fallback position is if they haven't allocated the responsibilities to somebody else, it falls back onto the client. The client duty holder roles are set out in Regulation 11A of the regulations, and it sets out the first and most important obligation on the part of the client is that they allocate sufficient time and resources to ensure that the design work and the building work are carried out in compliance with the building regulations and the building safety regime, and that they carry out periodic reviews to ensure that compliance, that they provide information that's necessary to the other duty holders for them to perform their role. And in respect of higher risk buildings under Regulation 11B, the client needs to make it clear to the other duty holders, hey guys, you are working on a higher risk building here, and therefore there is a greater duty holder role for you, and to be aware of that. I think that in addition, you've got Regulation 11D, obviously, if you've got more than one contractor on site and you've got more than one designer on site, the client has to specify who is going to be the principal designer and who is going to be the principal contractor. So
we're going to talk about contractors and designers. I think we can obviously group them into contractor and principal contractor, designer and principal designer. I think I think as we'll find out, the regimes are actually fairly similar.
Yeah. What I want to avoid here is just recounting a long list of obligations which apply to every duty holder. So I think realistically what we'll do is we'll look at the obligations of a contractor, and then we'll look at the obligations of a principal contractor. Basically, the principal contractor's obligations are the same as the contractor's, plus in respect of higher risk building obligations as well. So the contractor has an obligation not to start work unless they can confirm that they are fully okay and understand the building regulation regime, because you don't want somebody taking on responsibilities on site without that knowledge of the building safety regulations. They must ensure that anybody working under their control on site as the contractor complies with the building regulations regime. They need to make sure that they've got an obligation that they use reasonable steps to provide sufficient information to other contractors on the site to ensure compliance with the building regime. And as they are a contractor working with others, if they are aware potentially that the work of others being carried on the construction site alongside them isn't in compliance, then they've got an obligation to report that up to the principal contractor. In terms of the principal contractor roles, these are in addition to the basic contractor roles. So you're taking on the responsibility there of planning, managing and monitoring the construction phase to ensure that it complies with building regs. You are responsible for coordination with the other contractors and the principal designer to make sure that the works comply with the building regulations regime. And you've got to take reasonable steps to ensure that there is cooperation between the parties in that regard. I think that pretty much covers the additional principal contractor obligations. But once again, I've said I picked out the key ones there. On the note, you'll also find the full long list of each of the regulations that sets out the duty holders' responsibilities for contractor and principal contractor.
Yeah, and as we touched upon, very similar concepts apply in respect of designer and principal designer.
Yeah.
So
realistically there you've got regulation 11K and regulation 11M, which is virtually a repetition of those duty holder roles for the contractor and principal contractor. But instead of saying your duty in relation to the works, it's your duty in relation to the design, to cooperate, to manage, to monitor compliance, etc.
Yeah. And I see you've got the RIBA Principal Designer's Guide handily available there.
Yeah, I mean, just if anybody's interested doing the research and going through these new regulations, and particularly the responsibility of principal designer, I would recommend having a look at the RIBA Guide to Principal Designers. It sets out the legal obligations and perhaps also deals with the actual service scope that you'll need to comply with in terms of delivering that new duty holder role, because RIBA certainly consider that this is a role which architects who they represent are most likely to take up.
So we talked about it a little bit already, but this competency element, which is a new thread running through sort of everything we're really talking about today in this second part of the session. Should we talk a little bit about what a small word, is a long word, but it's one word. And it actually encompasses quite a heavy obligation actually when you start thinking and talking about it.
It makes perfect sense. I mean, you've got the new regime is about allocating responsibility to duty holders to ensure compliance with the new building regulation regime. The point is, it's all very well and good having duty holders to be responsible for this role, but it's no good if those duty holders aren't competent. So the building regulation regime also contains an obligation on those duty holders to be competent, and it specifies what competency is, and it sets out what competency is in Chapter 3 of Part 2A of the new building regulations inserted into building regulations 2010. So it defines competence broadly as those having the skills, knowledge and behaviours necessary to carry out the role. Well, skills and knowledge is fairly factually self-evident. You've done the training, you understand, you can demonstrate that you understand from the training that you've had that you've got those skills to carry out the role to ensure compliance with the building safety regulations. In addition to that, you've got the obligation to have that the person is competent if they can demonstrate the right behaviours in order to ensure compliance. And what are the necessary behaviours? Well, that's an ability to ensure compliance with the requirements and to refuse to carry out work or design which does not comply. So it's having the wherewithal and the strength of character and the good behaviour to say, well, this doesn't comply, or you're asking us to do something that won't comply, therefore we're refusing to do that. That's a good behaviour. The same in relation to cooperation. You've got to be able to demonstrate that you can engender a culture of cooperation between the duty holders and all of the stakeholders delivering the works on site to ensure compliance. And you've also got to be able to know when you don't know, which is terribly important, so that you refuse to take on roles and responsibilities that you don't have the skill or knowledge to carry out in order to achieve compliance. So if a particular area of design that you're reviewing is beyond your knowledge or understanding, and it's a key element of the works in relation to a high risk building, you need to make sure that you delegate that to somebody that can actually deal with it. And the final competency obligation is, it's all very well and good having the skills and knowledge and the good behaviours in relation to cooperation, but if you can't resource the duty holder role so that you've got the policies, procedures, systems and resources in place, the manpower, etc., to carry out that role, then you're not engendering the right behaviours to achieve building safety regulation regime requirements.
Now, to bring things full circle, James and I obviously looked a little bit at the drafting. So JCT amendments are covering quite a number of different areas. Let's bring it back now to talk about how JCT have dealt with the duty holder regime in respect of the drafting amendments.
Yeah, I mean, initially when you introduced me, you said Iain will talk about whether the JCT drafting committee had grasped the nettle in relation to this. My view of it is that they grasped the nettle, found that it stung, and then immediately dropped it again. I think that might be viewed as being slightly unkind, but the way I would look at it is JCT, as James said, have acknowledged that the building safety regime is in place. They acknowledge that in respect of pretty much all works, unless they're exempt or minor works, then a principal designer and a principal contractor and the duty holder regime will apply. So they've included in Article 6 and 7 the appointment of a principal designer and principal contractor for BSA as well as CDM requirements. And then they've effectively lumped that onto the contractor, but as a default, the contractor is appointed unless you specify otherwise. And then at clause 3, spot 16, spot 3, I think it is, of the JCT contract, they've basically said, and the principal designer and the principal contractor have an obligation to comply with the Building Safety Act requirements. That's okay, but it doesn't deal with the requirements in relation to higher risk buildings. Now, I understand JCT turning around and saying, well, not every construction project relates to a higher risk building, but I think that perhaps there could have been a schedule put in the back of the JCT that says if you have a higher risk building, then the following risks and obligations in relation to duty holder performance on higher risk buildings is now contained in that schedule, and it sets out a risk allocation, a standard risk allocation between the duty holders, between the employer that instructing the works, etc. And that isn't in there, which I think is problematic, particularly in relation to a number of the risks on higher risk buildings and the delivery of the works, because with higher risk buildings, you've got an obligation to comply with golden thread obligations, particularly in relation to keeping the information and compliance information for the requirements of achieving building regulation sign-off. You've got an obligation to notify and report in respect of major changes to the works of high-risk buildings carried out during the course of construction, which would need to be documented and reported up to the building safety regulator. And ultimately, you've got an obligation, if it's a high-risk building, well, it's not an obligation. If you need to occupy the building, you need to get sign-off from the building safety regulator at Gateway 3. Now, all of those obligations, in order for you to be able to use your building to get that ultimate sign-off, JCT doesn't deal with what the consequences are of the duty holders failing to achieve this. So who takes the time and money risk for these failures? Particularly the issue at the moment is obviously under JCT, you've got the provisions regarding achievement of practical completion. There's no provision in the JCT 2024 amendments or even in supplemental provisions that says what happens if the building safety gateway isn't achieved at Gateway 3. So you've issued PC, the building is ready, There's no liability on the contractor now to pay liquidated damages, because as far as they're concerned, the building is complete, but you still haven't got sign off from the building safety regulator, so you can't occupy the building. I think it would make sense. I think it would have been helpful if there were supplemental provisions relating to high-risk buildings that dealt with the allocation of the time and money risk in respect of those responsibilities. But in the absence of that, in respect of a lacuna on the part of the JCT committee dealing with high-risk buildings, it's for the lawyers to ultimately draft in their schedules of amendments how we deal with those issues, and take instructions from the client and come up with a bespoke response. I expect that there will be a uniform view as to how these risks are dealt with, and that will become more apparent over time, and perhaps the JCT committee and their next edition will adopt that. But at the moment, I think it's up to the lawyers to draft, frankly.
I think just tying together the two discussions that we've had, the discussion that I have with James, we've had a reshuffle of a number of the provisions from the supplementals into the front end, which should have freed up space for a little bit of drafting in the supplementals to deal with the duty holder regime.
Well, the fluctuation regime in respect of inflation have been, well, they've got rid of that now and put it somewhere else. So perhaps they could put a supplemental schedule in that deals with this, but we'll see.
There we have it in a nutshell. The new JCT, as easy as ABC. Of course, it's not. And as we've discussed today, there are many areas where it will be interesting to see how negotiations play out in practice. And I suspect there'll be a fair amount of drafting to do. I'd like to take this opportunity really for thank you really for joining us today. If you'd like to discuss anything raised in today's session, then please do contact us. As I mentioned at the outset, James and Iain's contact details will be made available together with the link to this recording and also the handout and the slides. And we would be more than happy to discuss anything further with you. Finally, it's just worth mentioning that we are looking to run a similar session in the autumn. So if there's any topic of particular interest, then please do let us know. Many thanks.
Thanks.